Aloha, everyone. My name is Rob Haak. I'm from the Hawaii Pacific Export Council, often just called HPEC. We are a nonprofit 501c3 in Honolulu, tasked with helping Hawaii and Pacific Island companies export their products. And to be clear, exporting is to a foreign country. It's not to California, the mainland, or even Guam, for example. It's to Japan, Korea, Germany, Canada, Mexico, etc. So an export by definition is to a foreign country. The Hawaii Pacific Export Council is fortunate to receive a grant from DBEDT, who in turn receives funds from SBA. That's part of the State Trade Expansion Program, or STEP. And Jamie Lum is here from DBEDT. She manages the Hawaii State Trade Expansion Program, or HiSTEP. So Jamie's going to explain a bit about the HiSTEP program, and then we'll jump into our main speaker, Seth Reiss, from Watanabe Ing, and he will talk about intellectual property considerations for exporters. So Jamie, please proceed and tell us more about the HiSTEP program.
Mahalo, Rob, and mahalo, Seth, for being here today, speaking on this important topic. Aloha, everyone, and thank you for joining us today. Thank you, Rob, for the introduction. So as Rob said, DBED, our department, does receive and administer on behalf of the state of Hawaii a grant from the SBA for our Hawaii State Trade Expansion Program, or HiSTEP. So the funds that we receive help to support various components of this program, but basically this is a export development program for Hawaii companies that are either new to export, or maybe you are exporting already but looking to expand. And what we are trying to do is to get more of our Hawaii companies really out there in the global marketplace, because Hawaii is a small market, and as the U.S. Department of Commerce likes to say, over 95% of the world's consumers are outside of the U.S. And so for our Hawaii companies, it's a great opportunity to expand and increase your sales by getting into exporting. So we're trying to increase the number of Hawaii companies that are exporting. We're trying to increase the dollar amount of exports that go out of Hawaii, are sold out of Hawaii. And really, we're trying to increase the number of markets around the world in which Hawaii goods and services are sold. So in order to qualify for the program, you need to be a small business and meet the SBA standards of a small business. You need to be registered in Hawaii with the Department of Commerce and Consumer Affairs, as well as the Department of Taxation. And you need to have a product or service that is at least 51% US made. In Hawaii, we do try to support those companies that meet 51% Hawaii made content. So we do, again, give priority to that. So just to talk a little bit about some of the components, we have our what we call our export readiness, of which this session is part of that. We do work with the Hawaii Pacific Export Council to put on these webinars on a monthly basis that cover different topics or cover different markets in which you might be interested in exporting to. In fact, we have one next week exporting to Australia and New Zealand, and that's next Wednesday at 3 p.m. So this is intended to give our companies information, especially those that may be new and may not know anything about exporting. So it'll give you an idea of the kinds of issues and components to exporting that you'll need to know about before you start getting into this export journey. As part of our export readiness, we also work with a number of partners with HPEC, with the Small Business Development Center, and with the Ming Center and the Veterans Business Center to help provide business advising services. So those are the two components, these webinars and the business advising services for export readiness. We also have used our STEP funds to support what we call our market expansion program, which is we help to organize trade shows, consumer shows, and then we also have some e-commerce opportunities that companies can take advantage of. So those are some activities that companies can participate in which we will subsidize the majority of the cost, and companies can, for a small participation fee, participate in some of these large trade shows and make it more affordable for companies to be a part of it. Much more affordable than if you went into a large trade show on your own. And then finally, we have what we call our company assistance, where companies can actually apply for funding to help support various export activities. So this is a separate process, and so companies can put together an export plan and then submit that for consideration. Funding, if awarded, is done on a reimbursement basis. So for companies that are new to export, they can apply for up to $5,000. And then for companies that are experienced exporters, what we call market expansion companies, they can apply for up to $15,000. So this is, I actually, although I'm not showing any slides today, Rob does have a slide deck that really goes into details about the HiSTEP program, and he will send it out to all of the participants. We are right now in the process of gearing up for our 2025 HiSTEP. We were just recently notified of receiving another award from SBA, so we're going to be updating our website, which is invest.hawaii.gov. If you go under the exporting tab, you can get all of the information on HiSTEP. So we'll be updating our registration form, and then which we hope to have ready for companies to start signing up by the end of October. And then for companies that are interested in applying for company assistance, that will be available in early November, will be due in early January. So again, we're updating all of these details on our website, and we'll also be having kickoff sessions at the end of October, where companies can, these will be in-person events, so you can learn more about HiSTEP. And we'll be going out to the neighbor islands as well to have sessions with companies. So we'll be putting out information about that very shortly. So thank you so much. If you have any questions, you can always reach out to me or reach out to Rob, and he knows how to get in touch with me. But again, thank you for joining us today. Aloha.
Great. Thank you so much, Jamie. And to reiterate, I do have a slide deck from Jamie that explains the HiSTEP program that I will circulate to the registered attendees after the talk today. This event is being recorded, and after some minor editing, I will also upload that to the Hawaii Pacific Export Council's YouTube channel. DBEDT puts it on their archive on their website as well. So don't feel that you have to write down all of these telephone numbers and things that you see, email addresses, because I will be sending them around to everyone. Okay, with that, let's move to our key speaker of the day is Seth Reiss. He's an intellectual property attorney at Watanabe Ing, and Seth has been very generous with his time with us over the years. Whenever we have an event that is focused on intellectual property. Seth has been our go-to person. I think he's extremely knowledgeable on the topic, and I'm so glad that he's able to join us today for this session. We've done this session about every 2 years, but I know that there's a lot of interest in it, and it's becoming almost an annual event for us. And I think it's very critical. A lot of our Hawaii companies fall down on this topic, particularly with trademarks and when they're entering foreign markets, they're not well protected. And somebody like Seth can solve so many of these problems for our companies before they run into trouble later. So with that, let me introduce Seth, and he will take it over, and we'll have a Q&A at the end. So please save your questions towards the end. Either type them into the Q&A part of Zoom, or email them to me or text me, and we'll make sure to get your questions answered. So with that, here is Seth Reiss. Thanks, Seth.
Thank you, Rob. Yeah, thank you all for attending today. I guess all I see on my screen pretty much is my slide deck, so I can't see the questions. I can't see the attendees, so I'll do my best, and hopefully I'll figure out how to get your questions at the end. So we're going to talk a little bit about intellectual property for exporters. It's primarily going to be trademarks, but first we'll talk about types of intellectual property. And they all potentially are at play in exports. There's patents. I think then, yeah, I'm going to be explaining each type briefly, and then we'll go into more detail, particularly in the trademark areas. 4 general types of intellectual property protection. Trade secrets are secrets. There's copyrights, trademarks, and patents. Patents are inventions. They have to be new and not obvious. They're for processes, manufacture, machines, compositions. They're also for plants and designs. They're country by country registration. So if you get protection, if you want protection, you have to file. You can't get patent protection without filing. You have to file in each country. And there's very strict rules for novelty. So if it's an old idea, you can't patent it. If you've disclosed it for more than a year, you can't patent it, and that requirement is absolute for foreign countries. So if you're dealing with any kind of invention and you're thinking of exporting, it's very important to consider whether patent protection is something you might need, and you have to consider at the very beginning. There's no going back. There is a patent cooperation treaty, which is a way you can file for patent protections in numerous countries at the same time, but you end up having to finish them individually in the country. It's very expensive. It's very expensive in the United States. It's very expensive everywhere. But if you do have an invention that hasn't been disclosed to the world, then it's something you need to think about before you start exporting. Copyrights are original works of authorship. They're in things like writing, pictures, websites, sculptures, music, performances, and they are automatic upon creation. So it's not a registration system. There's 2 countries that do have a registration. I think I just learned the other day that Canada may also have a registration system. The registration is not a requirement for protection. Protection is automatic. In America, registration is required for suing, and it is a good idea, but it is not required to claim the protection. The protection can be claimed at any point during the life of a copyright. The life of a copyright in the United States is 70 years plus the life of an author. It's quite a long time. There are copyright conventions treaties, which enable us to get automatic protection for our works everywhere in the world, almost everywhere in the world. I think there's like 170 countries that are a member to these copyright treaties. So in the area of copyright, it's automatic. You're protected automatically all over the world if you own it. And in order to enforce it, you may have to register and go through a few hurdles, but it's nothing like patent or trademark in terms of how you get your protection. Trade secrets, they are secrets. So there's no registration system. It's a matter of keeping things secret. There's there's statutes in every state of our country that protecting trade secrets. There's the federal law that protects trade secrets that travel in interstate commerce or internationally. Countries may or may not protect trade secrets to a certain extent. So if you're dealing with a trade secret and the exportee, the whoever you're sending it to may have access to it, you need to make sure you have an agreement that protects it, that would be enforceable according to the laws of that foreign country. Otherwise, trade secrets is a good idea not to export the secret, just to use the secret in the United States to make the export, and then you only have to worry about keeping it secret in your factory or plant. Trademarks is the biggest concern to an exporter, because you want to be able to use the name or your brand in the foreign country you're exporting to, and you want to make sure you're the only one who can. Trademark is an indicator of source or a designator of origin. It tells people who made the product, and it protects the goodwill that you generate by having a good product that's designed well and people can have confidence in. It's difference between, if you buy a Gucci bag, you have the faith that that bag is well made, and it's not gonna, the seams aren't gonna pop up apart in the first few weeks. Whereas if you buy the counterfeit, they may. Trade names are trademarks. Trade names are names of company. They're not registered federally. But if trade names are used with goods, they become trademarks. Trademarks protect brands for goods. And if trade names the business names are used with respect to services, then they become service marks, and they're protectable through service mark registration. There's at least two very important purposes of trademarks. It protects the businesses against unfair competition by other businesses who would pretend to be you, and such as pirates and copycats. It also protects consumers, so consumers know what they're getting. So you know the quality of what you're getting. And in the area of things like airplane parts and pharmaceuticals, you're getting a true or a counterfeit product can be the difference between having a safe product and having an unsafe product. So it's both make sure you get the quality you want, but it also can become a matter of safety. How do you get trademark rights? Well, in common law countries, you can get trademark rights through use. So in the United States, which is a Commonwealth country, once you start using a mark, you start accruing rights in the mark, and those rights can be sued upon. So you can get very valuable rights simply by using it. If you see little the SMs and TMs, those are letting you know that the owners of those brands consider them trademarks, but haven't registered them as such, or at least not federally. The other way to get registration is through, acquire rights is through registration. Registration usually strengthens the rights that you get through use. And you can register in the United States, you can register your marks on the state level as well as federally. It's generally a good idea to register for things federally if you ever plan to use your brand outside the state, or if somebody acquiring rights outside the state, like in the mainland with the same mark, might impact what you can do or impact your brand, even used locally. So I mentioned some of the other countries that have acquire rights by use, and they're Commonwealth countries. And so England and Canada are two examples of countries where you can acquire by use. Almost all other countries, you can only obtain trademark rights through registration. So you should assume, if you're outside the United States, you don't have rights unless you've registered. So register becomes very important if you want to protect your brand outside the United States. So here we talk about the ways you can register your marks, and when you get protection, what you get protection for. So there's no such thing as international protection. There is, but it's only based upon rights acquired in the individual countries. So as I mentioned, you can, in the United States, you can register in a state or nationally. In certain European countries, you can register, like Italy, since Italy was just a bunch of states until the middle 1800s. They also have a system where you can register by province or you know, internal state, or you can register nationally. Generally speaking, it's only the national registrations that are useful these days, although there's some historical vestiges of state or provincial registrations. There are trademark unions, which are very, very handy. And that's because you can register a mark in a union of countries and you get protection across all the countries. So in particular, the EU has a trademark union, and you file one application into that union and you get registration in 27 member states. And that's extremely valuable because it might only cost you a little bit of money, maybe $1,000 or a little more. And all of a sudden you're protected in 27 countries. They're very good if you can get it, and usually, oftentimes you can. Thing to remember about the EU Trademark Union is it doesn't cover a few of the countries that everybody assumes is in the EU. One is Switzerland, the other is Norway, and MT, I think it's Malta, but I'm gonna have to check. I once knew that, but anyway, in those three countries, so Norway sits very much in Europe, but it's not a part of this union. Switzerland, being the neutral country, is oftentimes not part of European treaties, and MT, I think that's Malta, is not part of the European Union. So if you're filing into Europe and you want to get every European countries, you have to do those three countries separate from the European filing. Benelux is also another European trademark union. That's kind of historic because these three countries are also in the EU. So if you file it in the EU, you don't have to worry about Benelux. But before there was an EU trademark treaty, these three Benelux countries had their own treaty. So there's a lot of historic registrations under Benelux, but modernly it's not very important. There's also an African trademark treaty. So the treaties provide for reciprocal rights. So what it means is, you know, if you're registered in one, you have the right to register in others, and you can register in others if it's available based upon your registration in your national country. So they're very important, but it's not automatic. In other words, if you register in the United States, it doesn't mean you're registered in other countries of the trademark treaty. It just means you have rights to register in other countries, and you may be able to register based upon your U.S. registration. So the rule is you have to worry about every country you want protection in. You have to do it separately, but there's a way to do it concurrently through what's called the Madrid Protocol. So the Madrid Protocol is a treaty that came into force in the last 20 or something years. So here we're talking about how you get the protection, different ways. So you can do individual domestic filings, which means domestic per the country. So it means you file in each country separately. That's the traditional way. That used to be the way we always did it. It used to be tough. It used to be tough because there were formalities. You had to get special notaries and go through consulates. And it would be very expensive and a big headache. But if you had a brand that was important enough, you go through it. And you also have to go through foreign counsel. U.S. counsel isn't qualified to file into other countries' trademark offices. You hire local counsel in each country, and then, as I said, you used to have to go through a big headache of formalities, document formalities. Pretty much now the formalities have gone away, and it's very easy. You know, within a couple of days, we can reach out to a foreign firm and get a filing, and it's not particularly expensive. And all the formalities gone everywhere except maybe in a couple of South American countries and Middle Eastern countries. Middle Eastern countries still have the headache, so a couple of them still do. And it's expensive and time consuming. I don't like to do it, but it's doable. Modernly, in the last 20 years, we've had the Madrid Protocol, and this has revolutionized getting trademark protection in foreign countries. And that's because you can file one application designating whatever countries you want. There's over 130 or so countries, maybe 170 countries, probably every country you're interested in, just about. There's a couple of Pacific Island nations that are not in this treaty, but almost every country, commercially important country, is. You just check the box for the country. You base it on your U.S. application and registration, and you know within a very short period of time, you file electronically, and all of a sudden you have an application pending in all the countries you click the box on, and it is relatively inexpensive. As I say, you can do all of Europe for maybe $1,500. Each country will cost you several $100s or more. A few countries are more expensive than others. I think Japan is a little bit more expensive than others. The US is typically one of the most expensive. But of course, we don't have to worry about that because we're filing out of the US into other countries. The US can be a headache for foreigners filing into the United States using this treaty. So basically, this application goes to a central bureau in Geneva. They review it just for formalities, and then they publish it to each country that you've designated. Each country will examine it. If there's no problem, they will register it. You'll get the registration in the foreign country, and without doing anything more. You just paid your fee up front. You paid your attorney to file it for you in the United States. And that's it, you get it. But sometimes, and it'll happen more often than not in certain countries, you get a refusal from a foreign country. And then you have to hire a foreign counsel to respond to that refusal. Again, it's oftentimes fairly simple and fairly inexpensive. Foreign counsel in general is cheaper than US counsel. So the headache is more for foreigners filing into the US because they're used to less expensive attorney's fees, and they file into the US and they get an objection from the US market trademark office. They have to hire one of us, and it tends to be a little more expensive than they're paying in their home country. Although many European countries and Japan and Korea, the fees there tend to be not so much different than fees we pay in the United States for trademark help. Here we go. So there's 114 members now of the Madrid Protocol. So that's the number of countries. I guess it covers 130 countries. So that's, one of the members is the EU Trademark Office. So if you file into the Trademark Office, you get those 27 countries. So that's the reason for that discrepancy, probably. You're filing a central application, as I mentioned, into Geneva. When it's time to renew, so let's say you filed your application, you designated, 15 countries, you got registrations in 14 of them or all 15 of them. 10 years later, they all come up from a renewal. Instead of having to renew individually in each country, you file just one renewal fee with Geneva and you get a renewal. The fee will be based on a cost for each country, but you don't have to pay attorneys in each country for the renewal. You just pay your US attorney to do the renewal for you. So it's efficient and inexpensive relative to what used to be. So the general rule is if you're going to file more than 2 countries, you should consider the Madrid filing because it may save you money. There are situations where for strategic reasons, you will not want to use the Madrids for certain countries, and that's because certain countries will object to certain type of marks, either because they examine marks in relation to marks that have already been registered, particularly in Asia, and also because certain English words tend to run into problems in Asia. So sometimes, and particularly in China, but other Asian countries as well, in order to get a registration protection in that country, it may be important to kind of use a modified strategy, which you may not be able to do through the treaty. So in these countries, we would recommend hiring a good trademark attorney in the country that you're having trouble with, and they will come up with a strategy for you that will work in their country to get some are all the protection you're looking for. Enforcement. So enforcement, if it's in a foreign country, the U.S. attorneys aren't qualified in a foreign country. Sometimes we do send cease and desist letters from the United States, which may get ignored. So the better policy would be to hire foreign counsel to send the letters. You can register marks with border controls of a foreign country in order to try to get stop counterfeit imports. Again, you may need foreign counsel help with that. You can do that here in the United States to stop counterfeit exports for coming in to the United States, but for a foreign country, you probably would need the help of foreign counsel. And then there's contested proceedings, which is litigation or trademark agency contested proceedings, which are called cancellations and oppositions. And of course, you'll need foreign counsel for those. They can get expensive. They will never get as expensive as U.S. litigation gets, but they aren't. The cost is not insignificant. I think we talked about this. So we've got so I guess I covered this already. This is slides. I haven't seen the slide deck for a while, so I anticipated these. Okay, what to watch out for? Scams. Scams are very, very common. They're getting more and more common. In fact, every time I open my email, there's a new scam. There's lots of solicitations. Whenever you file a trademark application, your information is public. You will get a scam. You will get a bogus email telling you that you should pay an extra few $1,000s for a publication that is worthless. You will get email saying that people are trying to register your name in a foreign domain name, typically is bogus. You will get emails saying it's time to renew your trademark and asking for lots of money up front. And they do that 3 years before it's actually due, hoping that once you give them your money, you're going to have to use them for the renewal. In certain areas, particularly India and South America, the trademark bar tends to be very litigious, and so they're always suggesting you file oppositions where you may not have to. And for a while, I don't know if it still happens in South America, one firm will file a trademark application simply so the other firm can reach out to an American business saying, guess what, your mark has been applied for, you better oppose it. So that's the conspiratorial oppositions. And then so I bet you some of you have already gotten the emails from China. Look, it may look like a registrar. It may actually be a registrar telling you that somebody's going to register your name in China. Don't you want to hire them to do it first? So it is true that it is a first to file system outside the United States. So you have to be first to file your trademark, but it doesn't mean you have to register every domain name possible to protect your brand. Okay, so here we go. We got to the question part. So since I've been talking, hopefully my face was visible. I guess what I'm seeing.
Oh no, we see you very
All right.
clearly. Thank you.
So I can't see questions. I can stop my sharing, Rob, but if I do that, I don't know what we'll see. Just me.
Well, it's okay. You can stop it if you'd like to. I have a bunch of questions came in to me.
Right. Why don't I stop it so that I see, at least I see you.
Sure. Great. So as you know, we have a free trade agreement between the US, Canada, and Mexico, the USMCA, formerly known as NAFTA. Do free trade agreements do anything for intellectual property protection? For example, is it relatively easy to get protection in Canada and Mexico?
So the answer is it doesn't affect the trademark system in terms of acquiring registration and general enforcement. I know that there was some provisions that impacted import export. So I can't answer that fully, in the sense that I know I know those free trade agreements do affect some remedies, but I can't tell you what they are. They're not something that I would come across in the course of my normal business. I think they're more specialized remedies, and it doesn't affect your the way you get protection in foreign countries. You still have to go through traditional methods, and there is no distinction between applying for trademark protection, for example, in Canada, or applying for it in a non-NAFTA country.
I see.
So it's still the same procedure.
Okay, let's talk for a minute about Japan. And I think we can lump in Korea as well, because as you know, well, when a Hawaii company hears the word export, there's automatic word association with Japan. A lot of our Hawaii companies try the Japanese market first. I don't always agree with that strategy. I think they should try to cut their export teeth on an easier market with shared language and what have you, like Canada, maybe Australia. But let's just assume that the Hawaii company is going to think about think about Japan. What do you recommend for that company? What should they be doing soon if they're thinking about going to the Tokyo International Gift Show, if they're starting this foray into exporting to Japan?
Okay, so again, it's mostly about trademarks. I mean, if they have an invention, they do have to think about patents. Generally, if you file a trademark in the United States, you have a 6-month period in which you can file in a foreign country and get the priority date of the US filing. That's true for patents for a whole year. So if they're about to launch a brand and they're going to Japan, they could actually wait 6 months to file in Japan. But if they have had the brand in the United States for a period of time, then they have to think about filing for protection in Japan before they go to that trade show, because they're going to be on display there, and somebody could misappropriate. But more than that, they probably want to search it. Searching is pretty inexpensive these days. To a certain extent, you can search for free if you just develop some skills on the internet. Because if they have a brand and they're going to Japan and that brand is somebody else and something else in Japan, then they have to think about a different strategy, right? In other words, if going to Japan and you have a name that's really big there for something similar, then you have to think about being something else there, not that brand. It's not a lot of work, but it's something to think about, both the search and considering filing for protection. As long as it's pending, you're okay, because you're there first and you'll get it before a pirate will, who might see you at the trade show. But
Okay.
those 2 steps would be good.
You mentioned,
the other
sorry,
thing,
go ahead.
Yeah, so certain products, we've come across certain products that are regulated in Japan, like aerosols are regulated in Japan. So you also, and this is a little bit outside IP, but you also should make sure whatever you're selling in Japan is not going to run into problems because of product regulations, because sometimes they're different. So it's good to get a consultation from somebody in Japan on that, to make sure it's not going to be a regulated product or a product that's prohibited from sale.
All right, let me give you another hypothetical that sort of is trying to answer one of the questions that came in. Let's say a company in Hawaii has successfully applied for and received a trademark in Japan. Things are going along smoothly, but then all of a sudden, through trade shows or business connections, whatever, they receive a contact from Korea, and they would like to there's a company that would like to buy from Korea. This thing sort of pops up very quickly, and they're trying to decide, should we sell this in Korea or not? How easy, or I guess how far in advance should a company be thinking about trademarking in markets that might pop up? Like right now, it's not on their, they're not exporting to Korea, for example. This is just purely hypothetical. They're not exporting to Korea. They're not exporting to Australia, but they could see that it could happen in a couple of years. I mean, should they be trademarking now, or do you wait until the last possible second?
But I think it's difficult because it's a budget issue, and it's luck, and it's what you're selling. Because if it's something that you expect to take off and just draw incredible attention, there's nothing to stop somebody from Korea going to a Japanese trade show. And so if something that you expect to take off, and you have the budget to file in every country you hope to sell one day, that's the way to do it. There's no use requirement in any country other than the United States to be using the mark in the foreign country to file. So you can file in any country whether you're using it there or not, which is not true in the United States. The United States has use requirement. Again, we tend to be the more expensive and the more difficult when it comes to getting protection. But so, you know, a lot of people will wait, and that's fine. If it's a product that doesn't draw a lot of attention, you know, maybe there's no real risk in waiting until you're ready to market in the second country to go file for protection there. But on the other hand, if your product does draw attention, and it, you know, and the very successful product may, then people might beat you to it if you don't do it early. The nice thing about that treaty, the Madrid, is that you can file in multiple countries fairly inexpensively. If you do it at the same time, it's even cheaper because you're paying your attorney only once. You know, I can only charge so much for checking a box. So if I check 15 boxes, I can't really charge very much more than checking one box. And then, you know, of course, there's a fee for each country, but it's not a great amount of money. On the other hand, a lot of companies I appreciate are small. They are a very tight budget, and you know, an extra few $1,000s is not something they want to spend. So you have to make a decision. You have to decide how much risk you want to take, and you have to try to predict what people might do when you're displaying at your first trade show in Japan, for example. How much attention that will draw.
That makes sense. I guess I'll close it with this last question, but I think it's a great question. Is what would your advice be to a company who's sort of just getting involved? They're starting. They have decent market in Hawaii. They've see some tourists coming in. The tourists are buying product. Tourists from Japan, tourists from Korea, Australia, etc. They feel that the market in these countries can support their product, and they'd like to start exploring that more. So what is your advice to this company who's just sort of getting started? They may not even have a trademark in the US yet. What should they do? And what can they roughly expect to spend?
So again, it depends on, you know, how many countries you're going to seek protection in. But I think the fact that you don't have a U.S. trademark is okay, because the way the treaty works, you can file on the U.S. and into the foreign countries on the same day. And again, that might even save you money. So that's not a problem. And as I explained, simply use in the United States provides you with some rights. Okay. So I guess the interesting thing is all those Japanese tourists are coming and seeing a brand, and, you know, are they going to go back home and register your mark for you in their name? You know, that's always a possibility. I guess Japanese may be a little more honorable than other cultures in that respect, but you know, we've had a lot of interest in Hawaii in our brands. There's been a number of restaurants on Oahu that have drawn interest from Japanese businessmen, or well, Japanese businesswomen and persons, because they want to open a restaurant with that name in Japan, maybe in Tokyo. And it's because, you know, all the Japanese tourists, they see this restaurant, they enjoy eating there. It's on the top of their list when they come here, and it's already a brand that's popular among people in Japan. And so generally what we've seen is, and as I say, these people tend to be honorable people. So they come here and they say, we'd like to buy your name for Japan. We'll spend this much money, and they put in their name in Japan. Now, the better practice would be for the Hawaii-based company to say, hey, you know, I don't want you owning my brand in Japan, but let's register my brand in my name in Japan, and I'll let you use it with license fees. So, you know, that way you control it. But, you know, frankly, it hasn't happened that way because many of the Hawaii-based folks are not that sophisticated, and they're just happy to get money to sell their names. But the better way is to, of course, control your name and brand. But I guess what I'm trying to say is, as long as people are seeing something that they're excited about when they come here from Japan or another country, there's the potential they're going to go back and do it in their country and do it in their name. So, you know, again, if you think you want to do business in a foreign country and people are getting to know your product here, you know, through tourism, you should consider, you know, filing in that country. And again, you can do it on the same day. You can file the U.S. application on the same day you file your Madrid application, designating the U.S. application you just filed. And how much you can spend, you know, a few thousand
Okay.
for a couple of countries.
All right, that's very helpful.
But the U.S. will cost you a couple of thousand, so you know it's but it starts about there.
All right, that's
You know,
that's super helpful. Is there do you have any advice for a company, like, you know, sticking with Japan, for example, if you're filing a trademark or a logo or something like that? Should our companies be thinking in also filing in the Japanese language version of the trademark? Is that common?
Yeah, it's not uncommon, and yes, I mean, most of my clients haven't. A few of my clients have, because it's a budget item. It depends on, you know, I'd say how anal the clients feel about trademarks. But you know, there's some companies that do have a considerable trademark budget. They will file a lot more trademarks, different versions of their mark, different marks. The Japanese language version of a mark can be commercially important and can help fight against infringement. So it's not a bad idea, but it is a budget item.
Understood. All right, I think with that, there's no further questions. I'm going to share my screen very quickly and go over these websites real quick to make sure everybody sees. Can you see my browser?
Yes, we see.
Great. So this is the DBEDT website Jamie was talking about, invest.hawaii.gov. If you go to that link, you'll see this exporting tab on the top. Click on that, and you get obviously some pull downs here, but just click on the HiSTEP program, and there's lots of information here. We're coming to the end of the 2024 cycle, and 2025 will be kicking off soon, so there'll be updates here, but this is a great way for everybody to keep abreast of what's going on. Secondly, here's Seth. Very good picture of Seth at Watanabe Ing. Here is the Hawaii Pacific Export Council archive on our YouTube channel. And I encourage everybody, if you haven't been here, go check it out. We have roughly, 89 videos approaching 100. I think the 2025 cycle put us over 100. Different topics, could be country specific, like exporting to the Philippines. Could be a specific topic like intellectual property that we had today, export finance, etc. So I encourage everybody to check that out. And we have Export Day coming up. This will be an in-person event on October 25th at the Homer Maxey International Trade Center at the Foreign Trade Zone at Pier 2 down on Ala Moana Boulevard. Look out for some information coming from HPEC and from DBET on that event. And then we'll be kicking off the 2025 cycle. As Jamie mentioned, we'll have an in-person meeting on Oahu, and we'll also be visiting the neighbor islands for in-person events to kick off. So hopefully we'll get to see everybody face to face. And if you have any suggestions or ideas you'd like to see for an upcoming event, please send that to me by email, text, or call me. And again, I will be editing this recording a little bit, uploading it to the archive here, and then sending around a link to everyone telling you where to find that video, as well as a link to the presentations that were given today by Jamie and Seth. So with that, let's wrap it up again. My name is Rob Haak from the Hawaii Pacific Export Council. Thank you very much to our speakers, Jamie Lum from DBET and Seth Reiss from Watanabe Ing for his sharing his advanced expertise on intellectual property protection for exporters. If anybody has any IP questions or concerns, please contact Seth and he can solve your problems quickly and easily. All right. Thanks again, everyone. Mahalo.